Welcome. In this presentation, we're going to take a real civil lawsuit, feed the complaint and the answer into an AI tool, and use it to draft written discovery under the Texas Rules of Civil Procedure. No theory, no hype, just a working demonstration. The legal profession in Texas is at a turning point. Generative AIs is no longer experimental. It's becoming foundational. For those of us who draft discovery, the role is shifting. We're moving from manual, labor-intensive drafting to something more like a supervisory function, where the lawyer acts as an architect of prompts and an auditor of machine-generated outputs. Under Ethics Opinion 705, technological competence is now part of the duty of competence. Today, we'll see what that looks like in practice. Quick disclaimer, everything here is for educational purposes. AI-generated discovery is a first draft, not a final product. You sign it, you own it. The case we're using for this demo is Twitter versus Musk, real publicly available pleadings adapted to Texas procedure. Here's the roadmap. First, the case, the claims and counterclaims. Second, prompt engineering. Then, and this is the key part, a side-by-side comparison showing why a vague prompt produces useless output and a detailed prompt produces real litigation tools. Then the full output. Lastly, the ethics, grounded in Opinion 705. In April 2022, Musk agreed to buy Twitter for $44 billion. No financing condition and no diligence condition. Then the market tanked and Musk wanted out. He sent a termination notice claiming Twitter misrepresented its user numbers. Twitter sued to force him to close. We picked this case for our demo because everybody knows it, the claims are diverse enough to generate rich discovery, and it's fully resolved. Pay close attention to the detail on the next two slides. The specific claims, the contract sections, the factual disputes, all of that goes directly into the prompt later. That's the lesson we're building toward. Twitter's complaint has 4 claims, each tied to specific contract sections. They point to the merger agreement's express specific performance clause under Section 9.9 to force Musk to close. Musk's failure to use best efforts in violation of Section 6.3. His disparaging tweets in violation of Section 6.8, and his misuse of the information access provision under 6.4. These section numbers go directly into the prompt, and they're what make the AI's output targeted instead of generic. For this demo, assume we represent Musk, who's asserted 5 counterclaims. Each is a separate discovery target. First, fraud. The fewer than 5% spam estimate was false. Second, breach of representations with specific contract sections. 4.5, 4.6, 4.14. Third, material adverse effect based on the Zotko whistleblower complaint. Fourth, information covenant breach. And lastly, ordinary course violations. Every one of these allegations, every contract section number, every factual dispute, it all goes into the prompt. The AI can't draft targeted discovery about claims it doesn't know about. Now let's talk about building the prompt. We use what we call the legal framework. L is for logic. Define the AI's role and attach the pleadings as a fact anchor. E is for elements. Map each allegation to the elements of each claim so the AI reasons about what discovery is actually needed. G is for goals. Specify the exact output and quantity. A is for authority. Direct the AI to follow the Texas rules specifically. And L is for limits. Build in constraints like no damages discovery and no improper marshal all evidence requests. This framework turns a generic AI interaction into a structured, defensible workflow. There are also 2 advanced techniques that improve output quality. First, chain of thought. Instead of just asking for discovery, tell the AI to think step by step. Identify the claim element first, then draft the request. This prevents boilerplate because the AI has to justify each request before writing it. Second, few-shot prompting. Give the AI 2 or 3 examples of your firm's preferred discovery style and tell it to match the tone and format. This keeps the output consistent with how you actually practice. Here's the authority section of the prompt. Level 2 case, under Rule 190.3, 25 interrogatory cap where subparts count separately. RFPs need reasonable particularity under Rule 196, and RFAs carry the deemed admitted consequence under Rule 198. Without this level of specificity, the output won't comply with any particular jurisdiction's rules. The task section, 15 ROGs avoiding discrete subparts, 20 document requests with named custodians, Agrawal, Siegel, Zatko, 15 RFAs designed for maximum strategic impact, merits only, no damages. These constraints are what separate useful output from a boilerplate dump. Now, before we show the output, let's see what happens when you skip all of this. This is what most people do the first time they try AI for discovery. 4 lines, the case name, a 1-sentence summary of each side, and a number. No procedural rules, no specific claims, no contract provisions, no factual disputes, no named custodians, and no quality constraints. Take a look at the 3 red boxes at the bottom. Those are the 3 things that are completely missing. Let's see what this produces. Here's what the naive prompt produces. An interrogatory that asks the other side to state all facts supporting their claim. That's asking them to marshal all their evidence, which is improper under Texas law and trivially easy to object to. A document request covering potentially millions of documents with no boundaries, which invites opposing counsel to move for a protective order. And an RFA that asks Twitter to admit it signed the contract. Technically correct, but strategically useless. Of course, they'll admit that. None of this creates any leverage. Now, let's see what our engineered prompt adds. Remember all the detail we walked through on slides 5, 6, and 7? The specific claims with contract section numbers? The counterclaims with elements mapped? The key contract provisions and factual disputes? That wasn't just background for the audience. That's what we fed into the prompt. On the left, what the naive prompt gave the AI to work with. On the right, what our engineered prompt adds. 5 specific claims with section numbers, 6 counterclaims with mapped elements, 7 key contract provisions, 9 specific factual disputes. The AI can't target what it doesn't know about. That's why the output is completely different. Same AI, same case. Completely different results. A vague interrogatory becomes a targeted question about raw data versus reported figures. Directly supporting the fraud element. A kitchen sink document request becomes a custodian-specific request targeting Zatko's internal security reports. Supporting the material adverse effect defense. And a throwaway RFA becomes a strategic trap. If they admit the CEO called declining engagement concerning, that could be impactful at trial. If they deny it, the document impeaches. The difference is not the technology, it's the prompt. Now let's look at more of the engineered output. 3 more highlights from the full 15 interrogatories. ROG 3 asks for the gap between raw reviewer data and published figures. ROG 7 targets how many MDAU users were actually served advertisements. If the answer is millions of users never saw a single ad, the whole metric is misleading. And ROG 12 asks whether anyone inside Twitter ever questioned the 5% estimate. Each one maps to a specific fraud element. 3 standout document requests. RFP 8 targets everything related to Zatko's time at Twitter. Internal reports, memos to the board about security failures. RFP 12 asks for Twitter's internal deliberations about what to share with Musk and what to withhold. That goes directly to the information covenant breach. And RFP 14 targets the ad load distribution data showing which users actually saw ads. 3 RFA highlights. RFA 4, the MDAU restatement 3 days after signing. Undeniable public fact, and the admission supports concealment. RFA 6 attacks the monetizable label if MDAU includes users who never saw an ad, calling them monetizable is misleading on its face. And RFA 14. If they admit the CEO called declining engagement concerning, that could be devastating. If they deny it, the document impeaches. This is strategic precision, not box checking. What worked? Every request mapped to a claim. Strategic RFAs, Texas rule compliance, named custodians, and speed, 50 requests in under a minute. But, and this is the critical part, you can't serve any of it without a thorough human review. Let's talk about why. In February 2025, the State Bar of Texas released Ethics Opinion 705, which is now the governing framework for AI use in Texas legal practice. Under Rule 1.01, competence now includes technological competence, understanding what AI can do, what it can't, and where it fails. Opinion 705 explicitly prohibits blindly relying on AI outputs. Every request must be independently verified. And the hallucination risk is real. AI can invent case law, fabricate facts, reference exhibits that don't exist. Submitting unverified AI output is a Rule 1.01 violation and a candor problem with the court. Two more critical areas from Opinion 705. On the left, confidentiality under Rule 1.05. You must vet your AI vendors for data safeguards. Use enterprise tools with zero retention policies. Sanitize prompts by redacting personally identifiable information. Consumer-grade free tools may share input data with third parties or use it for training, which could expose client secrets or waive privilege. On the right, billing. If AI generates 50 requests in 60 seconds, you cannot bill for hours you didn't work. You bill for prompt creation time and human review time. AI subscription costs can be passed to clients, but only with a prior agreement. Before you serve anything, run through this checklist. Verify every factual assertion in your RFAs against the actual record. Confirm discovery control plan compliance. Check for compound subparts that would exceed the interrogatory limit. Assess proportionality. Evaluate privilege implications. Apply your own strategic judgment on sequencing and timing. And disclose AI use if your court requires it. This is the human in the loop, the part no machine replaces. Here's the bottom line. AI can be a tremendously useful tool for legal drafting, but it is not a replacement for the lawyer. Under the guidance of Ethics Opinion 705, the Texas Bar has established a framework where AI acts as a sophisticated drafting partner. But the final work product remains the sole responsibility of the human advocate. The human in the loop remains the essential component of ethical discovery drafting. Thank you for watching.